Good afternoon, everyone. My name is David Lepofsky. By my regular employment, I'm a counsel at the Crown Law Office Criminal at the Ministry of the Attorney General for Ontario, and I argue criminal appeals principally in the Court of Appeal. I'm here today in my personal capacity as a volunteer who spent a lot of time advocating for equal rights and accessibility rights for people with disabilities. It is absolutely wonderful that over 1,100 people across the province of Ontario are watching this program live, and we hope more will tune in to watch it on replay later on. This afternoon, we are presenting the second in a series of webinars presented by the Law Society of Upper Canada on strategies that lawyers or paralegals can use to accommodate the needs of clients, witnesses, lawyers, paralegals, or others with disabilities in the courtroom. We did a first program last November 2012. If you were one of the 700 people who watched that program, we're going to cover new terrain today. If you didn't take part in that program, you still can. It's still available to you. We encourage you to. We won't be duplicating it, and you'll benefit even if you watch them in reverse order. What's the goal? The goal is to give you, lawyers and others who do advocacy in courts and tribunals, practical tips on what you can do to help ensure that people with disabilities can fully participate in the court process. We're going to spend about 30 seconds on substantive law. Here it goes. People with disabilities, whether their disability is a mental disability, a physical disability, a sensory disability, I'm blind, I have a sensory disability, or a intellectual disability, a mental health condition, a learning disability, whatever be their disability, the Charter of Rights in its Equality Guarantee, the Human Rights Code, and the Accessibility for Ontarians with Disabilities Act all guarantee them a right to fully participate in a barrier-free court system. End of substantive law. We're going to spend the rest of our time talking about what practically could be done to achieve that and what particularly lawyers or paralegals could do to help. We will be focusing today on a couple of specific areas which will supplement what we covered in the last program. Hopefully with your feedback, we can identify others in future programs. Let me tell you just 2 minutes of background, and then we're going to leap right into our first panel. And there's additional background available to you with the resource material that's provided online with this program. First, this topic, making our courts accessible for people with disabilities, is one that has been the subject of focused attention by the legal profession, the judiciary, and the Ontario government now really since the year 2005. In 2005, then Chief Justice Roy McMurtry announced that our courts have to take active steps to become fully accessible to people with disabilities. He appointed a committee under the leadership of Court of Appeal Justice Karen Weiler to develop a roadmap to get us there. The resulting report, available to you with the resources for today's program, is called the Weiler Committee Report. It provides that roadmap. I'm pleased to tell you that since that roadmap came out in 2007, there's been some progress. Not enough, but important progress nevertheless. For one thing, every major court facility is supposed to have a court accessibility coordinator. If you have an accessibility need, you as a lawyer or as a paralegal or your client or a witness or a family member have an accessibility need, whether the disability is physical, mental, sensory, learning, intellectual disability, whatever it may be, they're supposed to be your one-stop shopping to raise the concern and get the wheels moving to remove any barriers they might face. Use them. It's really important that you do that. The second key point is that a permanent committee was set up in 2007, a joint committee of the bench, the bar, and the government. It's called the Ontario Courts Accessibility Committee. A number of your presenters today are on that committee. And our task is to oversee implementation of the Weiler Committee report, to field ideas to government, to the judiciary and the legal profession, and to try to keep things moving. I think we're doing that, but we need your help. So feel free to send ideas. Either email them into this program today or use the accessibility link on the Ministry of the Attorney General's webpage provided in the materials today to send in your ideas or to raise concerns. Finally, before we leap into our first panel, let me just tell you that we will be having a question and answer period at the end of this session. If you want to email them in now, they will be tracked on an iPad that one of our presenters will be scanning, and we've got questions that you've sent in already, and we're incorporating where we can answers those questions throughout the program, if not by name, then at least by content. So with all of that background, what we'd like to do now is to focus our attention for the first part of this program on a couple of areas, specific disability areas, which have specific accommodation needs and which don't fall in the traditional image that you might have of accessibility. When we say accessibility, you probably think people in wheelchairs or walkers need ramps, they can't climb stairs. Those are, of course, important accessibility needs, but we're going to be talking about other ones right now. And in fact, the areas we're going to talk about come directly from feedback we got from our first program last fall, where people said they wanted to hear more. Our first panel, which we're about to start right now, is going to be on meeting the needs of people with hearing loss. We're not going to cover all the accommodations that can be applied, but we are going to talk about two important ones. They will be sign language interpretation and real-time captioning. By way of a little bit of background, the statistics that I've been given suggest that 1 in every 10 people in our province or our country has a hearing loss of some sort. People with hearing loss really divide into 3 categories. There are people who are deaf. That refers to people who were born with no hearing at all. There are people who are deafened. Those are people who used to be able to hear but lost all their hearing. And then there are people who are hard of hearing. Those are people who have some hearing, but below the kind of the level of hearing that people would ordinarily expect from a fully functioning hearing system. And of the accommodation requests that the Ontario government's court accessibility coordinators receive day by day, requests for accommodation for people with hearing loss is the #1 most common topic. Moreover, when the Weiler Committee did an informal survey of the legal profession back in 2006, we heard the same thing. So what we'd like to do right now is to turn to 2 very knowledgeable people about 2 very important accommodations. To my immediate left is Bonnie Rittersborn. She does sign language interpretation in the courts, and she's going to talk about doing sign language interpretation in the courts. I'm clever. And next to her is Kim Neeson, who does captioning, real-time captioning in courts and other venues, and she's going to talk to you about that access technology as well. By the way, for this program, we've given you bios on each speaker. We've also given you one or two liners on each speaker. I'm going to do the half-liner as I introduce each one so we don't eat up a lot of time. So, Bonnie, let me turn to you first. And could you please, you've got an audience of people out there who may have never had any experience with sign language. Who uses sign language, and what practical tips might you want to suggest to them if they've got a sign language interpreter in the courtroom so that the sign language interpreter can do their job and the person with hearing loss can benefit from their services?
Okay, David, thank you. First of all, let's talk about what sign language is not. It's not universal, and it's not manually coded English. Sign language is its own language with its own grammar and its own syntax. Sign language has no written form. Now, if you cannot hear, it's very difficult to learn to read because we learn to read by sounding out letters and words. That means that many deaf people who come into contact with the criminal justice system, if not most deaf people, will be functionally illiterate. For you lawyers and paralegals, it means that you cannot default to writing. You cannot rely on written English if you don't have a sign language interpreter.
You mean don't pass notes?
Do not pass notes. Most deaf people who you come in contact with in the criminal justice system will not be able to comprehend, say, a grade 5 written level. Okay, as indicated, sign language is not universal, and every country has their own sign language. Now, if your client is a new Canadian who does not know American Sign Language, this means you're going to require a deaf interpreter as well as a sign language interpreter. Someone who's deaf has an ability to naturally use signs and gestures to communicate. However, what this means is you're going to have 2 interpreters. Well, why do you need me if you have a deaf interpreter? Because the deaf interpreter is deaf. They will not hear what's going on in the courtroom. So I will translate from English to sign. The deaf interpreter will go from sign to gesture, and it will go to the end user, and then back again through the chain until it's voiced in the courtroom.
So that's for someone who doesn't know English. What about if they speak French?
We do have French Sign Language interpreters. Every country has their own sign language interpreter. In Canada, we have two. We have American Sign Language, and we have Langue Sign de Québec. I apologize for my accent. It is the sign language of Quebec, and there will be interpreters available, usually in Quebec, and they will be able to be brought into Ontario for people who use Quebec Sign Language.
So for people who are deaf but are using English, they would use American Sign Language?
That is correct. So what it means for you if you're using a deaf interpreter is that you're going to have to take whatever time you think is necessary and multiply it by 4, 5. So for something as simple as a remand, can you come back in next week? If you're using a deaf interpreter to somebody who does not know American Sign Language, who may not have English, you may say, we may end up saying in 7 sleeps, we may look at a wall calendar and explain what day we're at and what day we're returning. So something that could be a minute may take 5.
So that's more complex if it's somebody not, a deaf person who's not familiar with either American Sign Language
Or LSQ.
LSQ.
Right.
So focusing on people now who use ASL, because that's what you interpret in.
That's correct. Now, an ASL interpreter is very different than a spoken language interpreter. A spoken language interpreter will sit beside the accused and whisper into their ear. The accused looks around the courtroom. They can see where the sound is coming from. They can see who is speaking. Not so with a deaf person, because I will be sitting, or the interpreter will be sitting in front of that person. They will be looking at me so they can hear what is going on. If they look around the courtroom, they're going to be missing what is being said.
So you have to be in the line of sight of the person you're interpreting for.
That is correct.
And if they're in the prisoner's box, if it's a criminal case, where do you stand?
Okay, going to get there? Hold on. Now, what it means also is I'm going to have to indicate who is speaking to the deaf person. Who is speaking, I'm sorry, in the courtroom. So if it's the judge, I may be saying the judge is speaking, or the Crown is speaking, or the defense lawyer is speaking. I may point. Now, in hearing culture, pointing is incredibly inappropriate, but it's correct in deaf culture. Or I may do a body shift. So if the Crown is speaking and I'm interpreting, the judge then speaks, I may do a body shift. So there's a lot of movement with sign language as well. Now, you brought up a point where we stand. If there's an accused, perhaps in custody, then I'm going to be over here with the accused, standing in front of them while they're in custody. That means that they may not have a complete sight line to what's going on, and I'll be pointing wildly, perhaps moving, to indicate what's happening in the courtroom. I'll indicate what sounds are in the courtroom, if a cell phone goes off, if somebody interrupts. Now, if there's a simple matter, you're going to have a first appearance, something to be spoken to, you're going to need one sign language interpreter. If there's a more complicated matter, a guilty plea or a trial, you are going to need 2 interpreters for every deaf person. If you have a deaf accused, a deaf witness, and a deaf victim, you're going to need 6 interpreters. Means you're going to need an awful lot of lead time to be able to hire those interpreters. Now, why do we need so many interpreters? First of all, if there's a witness in the witness stand and I'm in front of that person over here at the witness stand, if a deaf person is in custody and over here, they're not going to have a sight line to be what's being said. They're not going to hear what is going on in the courtroom. So you need 1 interpreter here for the witness and 1 interpreter here for the accused. However, we work in pairs. So you now need 2 interpreters over here and 2 interpreters over here.
Why do you work in pairs?
A number of reasons. 1 is it's physically very taxing. 2 is there is no record of the interpretation in the transcripts because it's silent. So the interpreters support each other, feed each other, and make sure that the interpretation is as accurate as possible.
So one person is actually interpreting, the other's watching, and then you switch? That
is absolutely correct. We work 20 minutes on and 20 minutes off. However, on our off time, we're not sitting down relaxing. We're supporting the interpreter who's actively working.
Okay, give us some of the mistakes some people sometimes make when they're hearing people make when they're in a courtroom working with a sign interpreter.
Well, let's jump then to the do's and don'ts. How's that? One of the things is don't ask the interpreter questions. Don't say, where is he from? Was he born deaf? You can ask the deaf person directly, and the interpreter will interpret. Do treat the person like any other person. Don't hand the person a disclosure package and say, have a read through this. If there's something incorrect or there's something you disagree with, let me know. We're going back to the issue with literacy. Don't give the package to the interpreter and say, read this to him. The interpreter, number one, cannot provide information, cannot provide advice. So if while I'm interpreting this package to them, they say, well, what are the consequences of bail? What happens if I go to jail? I can't provide advice or information. That's what the lawyer is for. Don't say things in front of the deaf person that you don't want a deaf person to hear. If that person was hearing and you didn't want them to know something, you would walk out of earshot. Do the same thing, walk out of hearing distance from the interpreter, or else it will be interpreted to the client. We're certified and we have a code of ethics, and a strict code of ethics says that we interpret everything that we hear. Also, courtrooms provide interpreters. However, if you're meeting with a client outside the courtroom, you need to hire a sign language interpreter, because using friends or family raises questions of competency and ethical questions.
Like, what's the problem if your client's sister knows sign language? Why not use the sister to interpret?
Well, are you absolutely sure that they're going to be interpreting in the best interest of the client? Are you sure that they're going to be interpreting what you're saying? And perhaps there's a vested interest. The last thing I want to say is if there's an interpreter who's familiar with the process and who has been involved from the beginning towards resolution, that's fine. If an interpreter comes in for a trial or is parachuted in for some matter and is unfamiliar with the case, the interpreter may request a synopsis, the interpreter may request a copy of the information, and as much prep material as possible so that they have an understanding of the case, what's going on, and will provide the most correct interpretation. Just in our last 30 seconds here, if I was talking to you and you're interpreting for a deaf person, I say to you, does he have a lawyer? How would you interpret that? I would say, please ask the deaf person directly if he has a lawyer. Okay. But what actual gestures would you use? I don't mean what is the sign for that word, but would you interpret the words, do you have a lawyer, or would you simply translate verbatim what I just said? I would probably ask the lawyer to please speak directly in the first person to the deaf person, and I will interpret. All right. Thank you. Kim, I'm going to turn to you and say, what's different? You do captioning, real-time captioning. Can you tell us what it is and who uses it? Why doesn't everybody just use sign language if they have a hearing loss?
Okay. Captioner really is a very highly skilled court reporter who provides real-time voice-to-text translation. So as I am speaking right now, for example, Lisa is taking down what I'm saying, and it is being outputted in her software in English so that someone could read it. If, for example, I lost my hearing today, sign language would not be of any help to me simply because I cannot read sign language, but I can read the spoken word in text format. So that's where we come into play. So for people who are late deafened, hard of hearing, and we do deal with people with other types of disabilities, real-time captioning is a way for them to be able to access what is being said in a way that is meaningful to them.
So give us some practical tips, do's and don'ts, for somebody who's using real-time captioning in a courtroom to benefit somebody who's late deafened or hard of hearing.
Okay. I think one of the most important things to point out is we look very familiar because we look like a court reporter. However, our role is very different. We are not there to provide a verbatim transcript. We are there to make sure that the person or people who are hard of hearing are getting accessibility. So we may, for example, change words that, for example, if something's not going to come out in proper English, I might transpose it with another word that gives the same meaning. I'm going to be looking after that person that I'm working with. So, for example, if a cell phone rang and it caused an inappropriate moment in the proceedings, I would let that hard of hearing person know that a telephone just rang, and they'll understand why things have kind of gone off the rails because they're not hearing that phone. So that's the type of role that we are playing. We are not there to provide the verbatim transcript. So when we do work in court situations or hearings, we are not usually acting as the court reporter. We are acting as really an interpreter for that hard of hearing person. So we tend to either sit beside that person and they can view our screen. We can also provide independent screens so we can be sitting off to the side. So we're actually able to provide services to a number of people at one time by various means of viewing, so with monitors, laptop computers, and that sort of thing. So unlike ASL, where they are much more restricted in terms of, because there are people providing the service, we are able to leverage technology. So you want to think about when coming into it, for example, if it's a court hearing, who needs the service and where are they going to be situate? Are they going to be at counsel table, and are they also going to be at the witness table? We have had instances where the whole courtroom wants to see what we are providing in terms of service so we can project, for example, on an LCD projector.
So big screen.
Big screen, and everyone in the courtroom or the hearing room can see. But additionally, if counsel do need to speak to their witness or their client privately, and it is a hard of hearing person, we can also act as that person's ears in that situation as well. And much like Bonnie indicated, we are held to a code of ethics as well. So confidentiality is very important, and we totally respect that client's confidentiality, because as for solicitor-client privilege, people need to be able to communicate with their client, especially if they have a hearing loss. So there needs to be a way to do that in an accessible format.
So in a court, you might actually provide captioning for the private conversation between a lawyer and a client?
We may very well, and we will make sure we redact that out of any kind of transcript that might be produced later. I should add that's one of the bonuses of having real-time captioning is, of course, we do generate a transcript, at least in electronic format. And where we have a hard of hearing person client, we will often provide that transcript to them, because it's quite taxing to try and read all day what's being said, take it all in. Maybe you want to write some notes, give your lawyer some feedback. So to be able to do that, we will provide a rough draft to that client. So that's another way we can provide accessibility sort of after the fact.
Tell us what the difference is between captioning and note takers. I've heard something about note takers.
So note takers are people who are typing on a keyboard and they are summarizing what is being said. And I think particularly in the legal setting where really you want every nuance, we play on words a lot in the legal business. That's where captioning is a much better tool, because we try to be as verbatim as possible. That is our goal. We are able to punctuate, to indicate who is speaking, whereas a note taker is going to just try and grab the essence of what is being said. And in a place where your life may be at stake or your freedom, it may be very important to have a verbatim or as verbatim a translation as possible.
Okay, just in our last 30 seconds, Bonnie mentioned that there's a certification process, I think she did, for sign language interpreters. Is there a certification process for captioners so that we know that if we've hired someone that they actually meet some minimum qualifications to do it right?
There are no actual schools or certifying bodies in Canada, believe it or not, for CART or captioning, but many of us do voluntarily use the National Court Reporters Association certification. That is out of the United States. It's fairly rigorous, and you can be certified as a what is called a CCP, or certified CART provider.
What does CART stand for?
CART is Communication Access Real-Time Translation. It's very long. They came out with that acronym about 7 or 8 years ago when they wanted to differentiate between captioning that you see in TV versus CART, which means on-site, in-the-room captioning.
Very good. All right, I want to thank both of you, and I'm going to do a quick sum up and ask for our the next panel on mental health issues to come up. Bonnie and Kim will be back at the end of the program when we are taking questions from the audience. But thank you both very much. If I could just wrap up this first round with just a couple of important points. We emphasized this last November in the first program, and the area of sign language and in captioning are classic examples of this. Do not wait till the day before your hearing to request these accommodations. You've got to request these as soon as you possibly can, and give as much advance notice as you can. There is a shortage of sign language interpreters. There are, similarly, there's not an endless supply of real-time captioners. You want to make sure you get the request into the court months in advance if you can, or at least as far back as you can, contact the court access coordinator. The second message I want to share with you that comes from our first panel is this. If you could hear perfectly well, you're listening to two different presentations just now, or watching, about hearing loss. Two people with the identical hearing loss may use completely different accommodations. So you have to be aware of the fact that whenever you're looking to remove a barrier or provide accessibility for people with disabilities, don't think that one size fits all for a particular disability. I'm using Braille notes right now. There are a lot of blind folks who can't read Braille or can't read it at all. Some read it way better than I do, in fact, a lot do. So it is, for all of these, don't just figure, oh, they definitely need sign language. You've got to ask the individual who's going to need the accommodation what they need. And finally, the two accommodations we just talked about are not the only ones for hearing loss. I got a call from a paralegal with hearing loss whose needs are best met through a proper amplification system in the court. Our courts are increasingly providing FM-related transmission technology, but you've got to, again, request those in advance, make sure they're available, and indeed there are some new ways of approaching accommodation this individual shared with me that may not have even been tried yet, so there's room to explore new approaches. Let me move to our second panel. I've been joined up here by a bunch of very, very qualified, informed, and might I add, nice folks who are going to help with another disability that seems not to be in the traditional paradigm when you talk about accessibility, not about ramps and not about wheelchairs. We're talking about people with mental health issues. As a result of our first program, we got a lot of requests for more information about hearing loss. We just did that. And we got a lot of requests for strategies that lawyers can take for dealing with individuals with hearing loss. So our panel, and you'll see our printout, includes two criminal defense lawyers, or people with criminal defense backgrounds, Ted Kelly and Joe Wright. Joe now works for the review board. We have two civil counsel who are private practitioners who work in the civil field, Marshall Swadron and Joanne Cohen. We have Lori McAvoy, who was at our first program, who is one of the senior people in the ministry's team, Ministry of the Attorney General's team that works on accessibility issues and helps support court access coordinators, and Justice Beverly Brown of the Ontario Court of Justice, who presides, among other things, in the mental health court. So a lot of expertise right here. The Canadian Mental Health Association gave me the statistic that in any year, 1 in 5 people will have a mental health condition of some sort. Mental health issues are pervasive. Mental health disabilities quite often, if not almost always, are invisible. You won't know them, won't recognize them the way you would recognize somebody has a mobility disability if they're using a cane or a wheelchair, or a scooter or a walker, or the way a blind person like me would use a white cane. So we want to talk today not about the law governing mental health issues or the legal tests for capacity and that sort of thing. There's lots of good stuff on that in Law Society and other training materials. What we'd like to do today is instead talk about strategies that you as a lawyer can take. If you've got a client or a witness with a potential mental health issue that may need accommodation in court, how to figure out what the issue is, how to figure out what the needs are, and what kinds of accommodations might be practical in court. Our panel is a mixture of people doing civil and criminal work, so we're going to try to cross both thresholds or deal with both as much as we can. So what I'd like to do with that background in mind is to field some questions to our panel. And the first question I want to just throw out, and we're going to start with this one, asking Ted and Joe and Joanne, is how do you know if you've got a mental health issue, if your client or your witness has one, and how do you broach the topic in the first place? So Ted, do you want to start on that?
Sure. Thanks, David. Well, first of all, it can be difficult because individuals may be reluctant to identify living with a mental health disability. That's because they've had experience in the past of disclosure, which has resulted in stigmatization, or they may have had involvement in legal processes previously where negative outcomes were associated with disclosure. So, and it's also an intensely personal thing to disclose too, and particularly to a stranger who a new lawyer may be. My approach, and I think the approach of many counsel, is not to ask direct questions about mental illness during early stages of the interview, and instead encourage the client to provide an explanation of his or her position vis-a-vis the legal dispute or process that he's involved in, and also biographical information if he or she's willing to do so. I've found that clients will be eager to convey this type of information, or more readily willing to convey this type of information. Sometimes they'll be eager to, sometimes they'll be insistent upon doing that. And that only after they've provided that type of information do I provide them with an explanation of the process. So to put their concerns into context, it's after that, it's after that that I think it's more likely that issues of mental illness will arise. And one would hope that they would arise naturally. That is to say that the client will raise issues of mental illness. But if that's not happening, and if you believe that the issues are there, then if you've established a rapport and some degree of trust with a client over an extensive interview where you've done mostly listening rather than talking, it's more likely that your questions about mental illness will be received not in a guarded way, but there may be a chance, at least, that a better chance that the client will talk about the mental health issues and be able to discuss with you issues of accommodation. I would say this is very important, that sometimes these issues are not going to be raised completely or satisfactorily in a single interview. It may take multiple conversations before a client, and understandably so, feels comfortable enough to speak about these issues. I guess I would say finally that when considering issues of mental illness and strategies for accommodation, it's critically important to ensure that the client has a clear idea about the disclosure of these issues in the public forum, if that appears to be necessary to assist with accommodation, and that the client explicitly consents to disclosure about issues of mental illness and also requests for accommodation.
Okay, actually, I misspoke. Joe, you're off the hook. Joyanne, anything you can add from a civil practitioner's perspective about this?
Yes. I listen to how they speak and how the client is speaking, and whether the way in which the client is speaking is because of their state of mind or because of their ability to speak. I listen and watch them to find out how they're forming their beliefs and whether where they're getting their ideas from. How proportionally important they see various aspects of the case, and what impact the outcome of the case is going to have on the client. If somebody has faced a lot of trauma or abuse or has been abusive, that experience to me can be a signal that there could be things that have happened in the case or in their life that have an impact on their mental health. And from that point, I would start asking questions about mental health in the context of the experiences that they talk to me about.
Okay, that's great. Lori McAvoy, your involvement is from the ministry's end of trying to help frontline staff accommodate people over the counter. Any added tips you would give for how people can approach just figuring out whether there is an accessibility need that a person has due to mental health issues?
Yes, I think another approach, and we use it not just for mental health, but for other disabilities as well, but it's particularly helpful around mental health, is don't worry about the labels, but focus on what functionally does the person need to do that day and what functional environments are they going to be in, because by walking through that with them, you're going to trigger for them any things that might concern them. So you might describe that they need to be at the courthouse at 9, you might say that you're going to have to go in the front door, and then there's going to be a security scanner there will be some security guards, you're going to go through there, I'm going to meet you at courtroom 2, and by describing the day to them, how long they have to be there, when they have to be there, you're going to get a reaction from them as to things that concern them or that may be problematic for them. For example, we had one person who really had a very strong fear of police officers. So how are we going to help that person get through the courthouse in a way that doesn't impact them in a negative way? So by talking to your client about the day and what they can expect, you're going to get that conversation going about, so now is there any of that's going to be trouble for you or that concerns you, and you'll get that conversation going without getting into everything behind it in terms of what the mental illness is.
So whether you could probably work around labels like mental health issues and so on, if you like. Okay, let me go back to Joanne for a second. I want to just draw on something you said. You said that you watch to see if the difficulties that are, or the issues that are presenting are due to a mental health issue, or you said to a difficulty communicating. Could you just talk a bit more about that? What don't you want? What apples don't you want mixed with oranges?
Well, people may have certain physical illnesses or intellectual disabilities that could be confused with mental illness. And unless somebody is available to be an intermediary and to assist them with communicating, then they're more vulnerable and they've lost their autonomy in some way. If those illnesses, let's say cerebral palsy or the effects of a stroke, are confused with mental illness. So if I could find an intermediary who followed a certain protocol that I could rely on and see that the person was helping me understand the speech of the client, then I would be able to differentiate between the communication aspect and the mental health aspect. It would also help the client in their capacity assessment if any issues they had with communication were separated from issues with respect to their mental health.
Got it. Joe, you had a quick something you wanted to add in?
I think it's fairly common that a person may deny that they have a mental health issue, and you have to respect that, and I certainly endorsed what Ted says about that, but it doesn't make counsel's job any easier. But I think counsel has to work to gain the client's confidence, particularly somebody with a mental health issue. I think you have to explain to your client that you have both a duty to your client and to the court or tribunal. And I certainly want to reiterate what Ted said, that you start by listening. I think once you have the person's confidence, you'll find things easier. And I just want to conclude by saying if you perceive that your client needs an accommodation, you have to try to get that information out. Okay, let me now jump from the tough issue of how you identify a possible accommodation need and jump right into what kinds of accommodations have been tried or might be tried in a court. And by the way, some of this is all potentially equally relevant if your practice is before a tribunal, not a court. So first, I'm going to throw it back to Ted and Joe, and then
Justice Brown for the criminal court perspective, if I may, and then we're going to go to our two civil counsel to talk about it from a civil counsel perspective. So give us some ideas that people are sitting watching this in their offices and wondering, okay, well, what can you do for folks with mental health issues that'll make it easier for them to participate in a court process?
Well, David, just before we do that, we thought it would be useful to identify some of the common challenges that people with mental illness face. And I begin by saying that so many people who live with mental health disabilities also live with economic disadvantage and social isolation. They have limited formal education often and limited literacy skills, and they're often uncomfortable with telephone and especially electronic communication. They really prefer face-to-face communication. They sometimes have difficulty concentrating and in retaining information and communicating, and this is often the case in formal and public settings. And sometimes their ability to concentrate is time limited. That's to say that they can concentrate adequately, but only for short periods of time. The mentally ill people sometimes can have difficulty that results from the side effects of medication. Their intellectual functioning can sometimes be affected in pronounced ways, depending on when they've taken medication and whether the effects of the medication are wearing off, or whether they're experiencing withdrawal. They will typically, or not always, but quite often have limited understanding of the legal processes and potential consequences of those processes, and they're often very apprehensive about the processes, not unlike many people. But I've noticed that they experience this apprehension at a much higher level. And they may be suspicious of the process too. And that could be because of past negative experience, but it also could be due to symptomatology such as paranoia. And we have to be very careful about that and attempt to accommodate that difficulty that they face. Persons with disabilities may be less able and or inclined to control their emotions, expressions, behaviors, and again, especially during formal proceedings. They may have difficulty deferring comment about their case to appropriate times. They may have difficulty in refraining from speaking or from physical movement. And they may be more easily distracted by the physical environment, electronic devices, the physical build of, say, the courtroom, other conversations taking place, the actual space or the closeness or farness away from other people may have an impact upon them. And it's not uncommon for people with mental illness to dress in unconventional and sometimes provocative ways, and occasionally they will like to bring their possessions with them to the courthouse. They may not be cognizant of the concerns that their presentation raises with respect to court decorum or security. So these are some of the presentations and some of the challenges that persons with mental illness face, and I guess, Joe, I'll turn it over to you to talk about accommodation.
And just to explain, some present some of these. We're not saying all, of course, present all of these, and we're not getting into labels of diagnoses here today. It's not a psychology class. But at the front end, you could see any of those issues potentially arising. So, Joe, what kind of things can be done in a courtroom to help ensure that a person with some of those issues might be able, nevertheless, to participate effectively in a court?
Well, assisting somebody's comfort level is certainly one thing, and one way to do that is having a support person attend with the individual, whether that happens to be an accused or a witness, for example. And let's face it, sometimes it's stressful and anxiety-producing for lawyers to be in court. So then you think how much more so it is for a civilian, and then if it's somebody that may have a mental health issue, it just ups the ante a whole lot. So having a support person there, and to me there's no reason why that you can't identify that person the same way that you might introduce another person who's in the body of the court to the court is something that you can do. That person may figure in the proceedings later. Your client may have an attitude about the position of the judge. That person may feel that they should be close to or far away from the judge. There may be a reason why that person should give evidence, not from the witness box, but from the counsel table. I think you have to account for why that is, but that's something that I think probably can be canvassed before trial or hearing. And at least if you raise the issue, you can see if there's an accommodation that can be made. I think some litigants need a lot of physical space. I think Ted's alluded to that. You may need to explain why. If that person has paranoia, that may be one reason. If they're afraid of being touched, they need to have extra physical space around them when they're giving evidence or when they're in the courtroom. Giving an individual a quiet place to go before they testify might be an important factor in having a successful hearing. I think nowadays, in an era where there are victim witness coordinators in a courthouse, there is probably an additional resource to find somewhere for a person with a mental health disability who needs to have some quiet space around them before they participate in a hearing to accommodate that person. Another thing, and this is, I think, one that needs to be canvassed beforehand, is perhaps holding hearings for only half a day or having the court agree that they're only going to proceed half a day at a time.
Could you tell us why?
Well, people often have limited concentration spans or other forms of medical needs that dictate that they can concentrate or participate fully in their trial, if that's what it is, for limited amounts of time. And this kind of ties into my next point. Some times of the day are better for individuals to participate in a hearing, and that may be related to their medication schedule. Medication may introduce drowsiness or other, there may be other medication factors. So you may want to try to accommodate that individual, whether it's giving evidence or sitting through a trial or a hearing, by either arranging beforehand that their medication is provided at an opportune or timely juncture, or ensuring that the court or hearing knows that the hearing needs to proceed at a certain time. I think you also need to liaise with, to the extent possible, with the accessibility coordinator in a courthouse if it's a courthouse proceeding. And again, I want to reiterate that timeliness is very important. Do it early and do it often if you're going to try to seek an accommodation. The more notice that you provide, I think, augurs well for your client or the individual witness to get an accommodation.
I'm just going to pick up from there, Joe. Thanks very much. Talking about people who might appear in court before judges, and when they're in specialty courts like a mental health court such as 102 Court at Old City Hall, the court is almost prepared for a lot of these situations, and it's almost ready to accommodate it because that is the large percentage of the population that we deal with. And frankly, if any of you practice in that court, you know what it's like the minute you walk in there. It has a completely different feel to it from any other court, for example, at Old City Hall. So it's important, though, because you may have people with mental health issues outside of a specialty court, be it a trial court or a preliminary hearing court. So you may appear either in front of a judge who doesn't have a lot of dealings with mentally ill people, or you might deal with one who does, but as David said at the outset, the person walking into court may appear physically as someone who has no special issues. So following up on what Ted and Joe have said, it's important to telegraph to the judge so accommodations can be made in a respectful way what you want the judge to do or what you want the judge to keep in mind as the case goes on. And I think it's important to say, in a respectful way, including your client or including anyone who is involved in the courtroom with respect to what you're saying, not talking over them, not using labels that they don't understand, but yet finding a subtle way to telegraph the judge what you want the judge to know. So, for example, you need to be mindful of the fact that if it is a trial court or preliminary hearing court, the judge isn't just going to be considering the needs of your client or the needs of that witness. The judge is mindful of everything going on in the courtroom at that one given point in time. So, for example, generally the court's concerned with decorum and control of the courtroom. So again, if you have a client or if there's going to be a witness called who likes to pace around, who likes to move from position to position, find a way, as has been stated, to telegraph that to the judge, such as, Your Honor, my client likes to move around a little bit. I hope that's okay. You don't even have to put a label on it. It will become apparent to a judge who's watching the cues that that's the issue that needs to be dealt with in the courtroom. I think it's also important to telegraph, too, if this is going to be someone giving evidence on the column of credibility and reliability, if there are special things that need to be taken into account, and generally there isn't an issue with respect to this as far as demeanor and so on, that maybe you should be planting a seed with the judge that my client has certain things going on. For example, if it's someone who, as a result of their mental health issue, is generally perceived as being disrespectful, maybe it's someone who has Tourette's syndrome, for example, will be acting inappropriately. Again, find a way to telegraph that to the court so the court can control that behavior in an appropriate way. But bearing in mind that, for example, if it's an accused that's swearing at a complainant, the judge has to find a way to deal with that as well, bearing in mind the needs of everyone in the courtroom. But having said that, it's important to also, in the spirit of including everyone in the courtroom and having a comfortable environment for everyone who, for example, for me that enters my court, that's my goal, making sure that everyone is speaking in plain language to the extent they can do that. And I know it's very hard sometimes for lawyers to do that, but often there are people who appear in the courtroom that don't understand the legal terminology that you're using. It's more problematic, of course, if it's your client, but I know I try to be careful with that. If I'm the judge, you want to make sure that everyone who's in your courtroom understands what you're saying to them, yet not that you're talking down to them. So you need to find a way to do that. You may need to alter your pace of speech. Again, if you telegraph to the judge that there's an issue with respect to comprehension or some cognitive issue, that maybe it's better if they speak slowly. And you could say something like, Your Honor, I find it's helpful, if it's the client, for example, I find it's helpful in meeting with my client if I speak a little bit slower than I normally do because the level of comprehension goes up. For example, that's totally understandable to me. You don't need to say anything more than that. Again, you don't need to give me a label. I just want to accommodate what I think someone said earlier as far as a functionality approach. I want to accommodate that person coming in the courtroom. The other thing is sometimes there are special situations such as clothing, and Ted referred to it a moment ago. Sometimes people have certain delusions about who they are. They're otherwise fit for the purposes of criminal proceedings, but they may dress in a certain way that's not conventional, appropriate dress for a courtroom. So again, you might want to, if your client comes in that day, to telegraph that. The other point is picking up on what was said earlier. If your client is taking medication, if you're on a case that goes more than one day, and if there is a change one day to your client's appearance such that, for example, the first day they appeared perfectly normal, but by the time they're back on the second day before that judge, they're going to appear quite differently, you might want to consider whether or not you make any mention with respect to medication or lack thereof for the judge to figure out how to handle what's going on in the courtroom or whether the person's giving testimony. And I know, Ted, that you wanted to comment a little bit, too, in terms of behavior in the courtroom.
Really, I think that the clients, as you say, the behavior or the information about the client's presentation or behavior can be telegraphed to the judge in advance of proceedings starting, especially in cases where credibility assessments are going to be important. I would say, though, too, about this issue of, I guess, communicating with the judge about a client's disability is that what should occur, I think, is that the client shouldn't be surprised by the counsel's attempt to communicate the existence of a disability and the need for accommodation. Always, the client should be prepared for that type of communication, so that he's not surprised or she's not offended by that information getting out. That's really quite important. And again, I think that conversation must take place well in advance of the proceeding. The client should be well prepared for that, and it gets back, I think, to the most basic issue of accommodation, which is that the relationship between counsel and client should be one where there has been ample opportunity for trust, rapport to develop, and for these issues to be carefully considered before you get to the courthouse.
Okay, for our last 5 minutes, I'm going to ask if Marshall and then Joyanne can add in how much of that, from a criminal law perspective, applies to civil litigation or tribunal work, and what else might you add? Let's start with Marshall.
I'd say that all of the comments that we've heard in the criminal context are applicable as appropriate to tribunals and to the civil context. We have to remember as well, though, that in civil litigation, many of the proceedings occur by way of application or motion, and the manner in which someone's going to give evidence is not live in front of the judicial officer, but it's going to be by way of affidavit. And this is where lawyers play a very important role. Lawyers are essentially gatekeepers. They're the persons that will assist someone in swearing an affidavit or in some cases not take an affidavit. But the rules are very permissive, and lawyers can ensure that someone is able to tell their story and to swear an affidavit. The rules are simple. It's the ability to communicate and the ability to appreciate the consequences of telling the truth, and that's a pretty low threshold. So once that happens, someone may be subject to cross-examination, and some clients will do better in a judicial forum where there's a judge present, and one is able to, with leave, have evidence given viva voce in front of the judicial officer or master hearing a motion or an application. And if that is the best way to get that client's story out, then that should be used. And otherwise, clients should be enabled to swear affidavits. Even a client that may have a cognitive problem such that they can't later on, because of a short-term memory problem, remember that they've sworn an affidavit. That's very similar to somebody, for example, who would be illiterate and for whom the rules make special provision that they can swear affidavits, as long as the person can verify afterward that evidence in that affidavit is true. Independent of being able to recall whether they swore it or not, then that affidavit can be taken.
Okay, Joyanne?
Well, I agree with Marshall that, and with people who spoke about what happens in the criminal courts, that you need more flexibility. And the flexibility in presenting affidavits can go so far as requesting that motions, for example, be arranged with the judge's assistant and be with the judge over the phone. I mean, you can get that flexible.
Okay, we're going to bring this panel to an end, and I'm going to thank our panelists who are going to take a brief powder and then come right back at the very end when we take questions from our from those of you watching this back in your offices or elsewhere. And I'm going to invite Justices Anne Malloy and Howard Bornstein to come up for our next panel. Let me just wrap up the mental health panel with a couple of observations. If we made the point earlier that it's important to communicate to the court as early as possible needs, like the need for sign language or for captioning, what we, I think, encourage you to take away from the mental health panel is that it's really important for you to explore these accommodation needs with your clients and their witnesses as early in the retainer as you can. A disability like blindness or total deafness, you'll know about pretty fast. But other issues like those we've talked about in the last panel require you to do some active work on your part to find out if there is a need and to start being creative in coming up with ways of both of identifying what the solutions are and how to deal with it. Let me now move to our last panel, and we're joined by Justice Anne Malloy of the Superior Court, Justice Howard Bornstein, who sits in criminal cases in the Ontario Court of Justice. Both are members of the Court's Accessibility Committee, and both have been integrally involved in our efforts at overseeing the implementation of the Weiler Committee report. Let me lead off by just saying what we're going to try to do here is, up till now, in our first program especially, and in parts of today, we've talked about some of the more common or recurring accommodation needs. And many that you will see in your practice if your witnesses or clients or others you're working with are one of the 1.7 million Ontarians who have a disability. You sure can't miss us, we're everywhere. Most of them will be one of these recurring kind of accommodations. But some cases are more complex. And so today what I'm going to be talking to Justices Malloy and Bornstein about are the more complex kind of issues that can arise. Actually, I'm going to totally catch you both off guard with asking you something I didn't even raise beforehand. But in any event, you were on a panel with us last November, and back then I asked if you canvass at pretrials whether people have accessibility needs among their witnesses or their clients, and you had said that for the most part, if not totally, people don't raise any, counsel don't. Since we did our last program in November, what have you been asked for, if anything, by counsel at pretrials in cases you've been involved in? Can I start with Anne?
I haven't done a pretrial.
You haven't, so therefore you haven't been asked. Howard?
I did pretrials actually today, and I've been doing them since November, and I wonder if anyone saw it on the last occasion. You mentioned 1.7 million people with disabilities in Ontario. Every single pretrial I ask both counsel whether the accused in the criminal context or any of the witnesses have any disabilities that need to be accommodated, and to a one, the answer is always the same, no. That there's not a single request for disability to be accommodated, and I can't help but wonder if they've really investigated it, because I don't know how many pretrials I do. If I do 20 a month, that's 200 a year, and my colleagues have the same experience. Nobody's asking for accommodation.
Well, I just suggest, I think, that there are more needs out there that lawyers could be finding out about, or absolutely none of the 1.7 million Ontarians who have a disability happen to have anything to do randomly with the courts that you've been involved in, which I think is unlikely. Let's talk about some more challenging questions. Justice Malloy, let me start with you. We've talked about bringing accommodation requests to the court. When should counsel ask a court access coordinator for an accommodation need, and when should they be raising it directly with the judge and not going to the access coordinator? And when's it okay to raise it ex parte, and when do you give notice to the other side?
Okay. I think always start with the accessibility coordinator is the best plan. There are some accommodations, however, that the accessibility coordinator cannot provide, and those would be things that affect the trial process itself. So they would be things like scheduling or the use of a support person in the courtroom, the way a person is going to testify, how a person might be presenting in the courtroom and might need to be accommodated, those tangible things that actually occur in the courtroom that can affect trial process. So a trial coordinator or an access coordinator can't tell the trial judge how to run the trial. Those are issues that only the trial judge can deal with. But it's a good move to start first with the accessibility coordinator so that you can figure out what is the best process here. Sometimes the trial judge is not known until the morning of the trial. In Toronto, that's very common. Sometimes you can get some direction from whoever's the head of a particular team or from the regional senior judge in a particular jurisdiction. So you can get some direction on whether you can have another judge hear a motion ahead of time or whether they can assign the trial judge for that trial and get before that judge ahead of time. You could give written notice to the accessibility coordinator of what the issue is, and the coordinator could take it to the judge and say, what process do you want to use here? Do you want to deal with this on the morning of the trial? Do you want to do it ahead of time? Do you want to do it in writing? So as long as the judge knows what's involved, they can make that call. In terms of when you would ever go to a judge ex parte, never. When would you give notice if it's a motion that has to go before a judge? Always. I hate to be so definitive about it, but you cannot be speaking directly to a trial judge about a matter that affects the conduct of the trial without notice to the other side.
Okay, thank you. Justice Bornstein, I want to pick up on something that we heard about at the last panel, and that we also got some questions emailed in about from people enrolling for this program who sent in questions in advance, which we appreciated very much. And the question is this: if you're the trial judge, you aren't a repository of knowledge about all disabilities. If I'm going to be calling a witness who has an intellectual disability or some kind of disability where I want you, or if it's a jury, to know about how it affects their memory or their reasoning or their answering questions so they can fairly evaluate their evidence, how do I let you or the jury know?
Well, thank you. First of all, the question assumes that the disability in question is relevant and will affect or potentially might affect the assessment of the witness. How do you inform the court? The last panel, Justice Brown, Ted Kelly, and the others, I thought, gave great advice about the telegraphing to the judge. I think that's probably the most effective way to do that. You're not seeking an advantage, obviously. You're simply trying to eliminate any potential prejudice or disadvantage caused by the disability. And I mean, that is the goal. So how do you do that? There's different ways to do that. Telegraphing seems to me, having listened to the last panel, probably practically the best way to do it. It also depends. Evidence could be called. Is evidence the preferred method? It depends on how contentious the information you want to put before the court.
What kind of evidence are you thinking of?
Well, if somebody wants to talk about how the particular disability in question may affect the way the witness is answering questions, even demeanor, if the other side is not prepared to accept it, if it's not something that could be readily known. Most of the examples that we heard on the last panel would probably be easily digested by the court, and my client wants to walk around, as you said, or if we speak more slowly, the client will comprehend more. I think that's completely fine. But if there's something a bit more contentious that somebody wants to call to explain not only the evidence but the conduct behind the trial, then I would think that evidence would probably have to be called, especially if it's contentious and not accepted by the other side. So what sort of evidence could be called? There's different you might need to call an expert if it meets the Mohan criteria, if it's something that we need to have in order to understand. But the ultimate issue is not to advantage the one side, but to eliminate any barriers or disadvantages.
Can I add something
Sure.
to that? There's a quite interesting case out of the Supreme Court of Canada fairly recently, 2012. Maybe about a year, I've got it right here actually, it's February 2012. The name of the case is Regina and DAI. And the issue in that case was the competence of a witness to testify, but a lot of the principles in the case apply equally to information a court might need in, say, assessing credibility, understanding mannerisms of a witness, getting a handle on how to judge that person's evidence. And what the court said there is that expert evidence is not necessarily the best. What they thought would be the very best evidence to understand how the disability affects a person in their day-to-day lives and how they speak and how they communicate to people is somebody who knows the witness very well, somebody who has day-to-day contact with the witness. So a parent, a sibling, a spouse, somebody intimately familiar. Now, I mean, against that, you have to also recognize that that person might have a bias, and it depends on the kind of case and the kind of witness and the kind of disability, but first-hand knowledge is always best. If not a family member, you might have a care provider, a personal assistant, a teacher, someone who has that kind of contact. And secondly, if you're going to go to an expert, the Supreme Court said that it would be preferable to have an expert who has direct knowledge, a treating physician, somebody who knows that person on a regular basis, not just brought in to talk generally about a disability. And I think the other thing that the court recognized is the most important source of information is from the person themselves. So if the person is able to communicate what their needs are, that's the best source. So it's a handy little reference. It's not a very long case, but it's a great little synopsis of the kinds of evidence you might be thinking about.
Okay, let me just follow up with you with our next more complicated problem. We've heard about people who may not be able to, in our last panel we heard about people, whether it may be a mental health issue or whatever, can't really get through a whole day.
Yeah.
So let's assume whether it's for that reason or because of a chronic fatigue condition, a party says, look, we have a 10-day trial, but the party, because of whatever disability, really can't do more than half a day at a time, and they got to have a 3 days clear between because of the strain it puts on them. So we're talking about, Monday and Thursday, half days over 10 weeks. Opposing party says, look, we can't manage that schedule for whatever reason. Counsel's busy, interrupting the proceeding. They want to run the trial and get it over with. What do we do?
Well, again, everything depends on context. It would depend on what was the reason that the responding party was unable to accommodate. It might depend on the nature of the individual who wants the accommodation. Is it the accused person in a criminal trial? If that's the case, we would just have to accommodate, period. And that could be done. If, however, let's say it's a complainant in a criminal trial, well, that person has less right to be present. And if that interferes with the accused's right to a speedy trial, Section 7 principles might come in, Section 11B, delay issues might come in, that would trump the ability of someone who's not a necessary party to the proceeding being present. So let's assume that's not the case. Let's assume it's not just a witness in the trial who wants to be there, but a party with a vested interest. And let's assume it's not a criminal accused, because we would always accommodate that. Now we're into a balancing exercise, and it would depend on why it is that the responding party feels that can't be done. I think from the court's perspective it can be done. We've even done trials in hospital rooms. We do trials by video link. We can do that, and we can do them intermittently. We often do intermittent trials just because of scheduling reasons. So that's workable. I don't know what valid reason there could be on the other side, as long as there's sufficient notice ahead of time. But, if you're the responding counsel and you've blocked off 2 weeks to do this trial, and it's been set for this date for 1.5 years, and you show up for trial, and now counsel says for the first time, well, we can only do 3 hours a week, so it's going to take us 3 months to do this trial now. Well, that's just not reasonable.
Which goes back to the importance of identifying these issues as soon as you can in the process.
Key.
Even though it's not on all the checklists we got when we were bar admission students or learning all of these practice skills early on. Justice Bornstein, we're going to jump to another problem, which I know at judicial training conferences, a hot topic that it gets a lot of attention is what the heck does a judge do to ensure a fair trial when a party is self-represented? Let's add to that mix that they're self-represented and they either have a cognitive or an intellectual disability or a mental health issue. A, what can a judge do? And B, what will a judge expect of opposing counsel? So you have a self-represented individual on one side and a lawyer on the other. What kind of things might be done by the judge to try to offset this situation? And what will the judge be expecting of counsel on the other side?
Well, in terms of what I would expect from counsel from the other side, in the criminal context, again, which I said it's easy, you would expect the Crown to do everything to accommodate the disabilities in question, whether it's through scheduling or through shorter days or breaks or anything else. But I think those same principles, as we learned from the last panel, apply as well in the civil context. We're all in court. We all have a responsibility to try to accommodate people with disabilities so that they can not face any barriers. We certainly can't be countenancing counsel not trying to do that or trying at worst to exploit it. Practically speaking, what counsel would do that? It would be completely offensive to the court. And I think everybody, or most people, are obviously well-intentioned and would do whatever they could to assist, whether it's through scheduling or otherwise. I won't repeat what was said in the last answer. In terms of what the judge can do, it's the same thing that you would do in any other case. You would try to gently find out what you can do through things that are only obvious to you. If you don't have any assistance identifying things that are not obvious, it will become difficult, but perhaps they'll become apparent as they go along. In self-represented trials, generally, sometimes I think Crowns feel it's the Crown against the judge. And not surprisingly, the judge finds his or her own reasoning persuasive often. When it comes to adding to that, having to accommodate somebody, it'll look even more as though the judge is siding with one side. Just as a practical matter, I would make sure that the self-represented person knows that as much as it may seem to him or her that I'm on his side, I'm not on his side, I'm on nobody's side. But you would just do those sorts of things to try to accommodate all of the issues that we've discussed at this panel and the last panel.
Can I add?
Sure, absolutely.
It's particularly problematic when you have a jury. It's always a problem if, as the judge, you're seen to be helping the person who's unrepresented and who has the disability against the other party that has a lawyer, whether that's in the criminal system or the civil system. But where you have a jury and it appears to the jury that you're helping the person with the disability, it's quite problematic. In those situations, I don't want to say always or even almost invariably, but very frequently would appoint amicus. I find that's a very good balance to make sure that the individual knows what his rights are without my telling it to him. And that person, if you choose him or her carefully, will have a better ability to develop some rapport with the individual and to put any issues before the court more easily. So I find having amicus really, really helpful.
Okay. We've got more to cover, but not enough time to, so we'll save it for program number 3. I want to thank both of you, but stay put because we're going to ask for the rest of all of our presenters to come up for our last few minutes. Do you have the iPad with you? I do. Keep the questions pouring in. Justice Bornstein will, with absolute judicial impartiality, pick the questions that he personally wants us to answer. This is going to look like we're posing for a class picture or something because we don't have enough seats for everyone. But just as everyone's getting in position, Lori, when you're here, I want to ask Lori McAvoy, just before we jump into the questions from the rest of you, to just give us a bit of a thumbnail sketch from the data, I guess, from last year, of what kind of requests are coming into court access coordinators across the province. What are the most, I'd indicated before, the most common one relates to hearing loss. But Lori, can you just give us a couple of, just a quick overview?
Yeah, so hearing you right, and it covered captioning and ISL, as you talked about before, as well as assistive listening devices, which are devices that can hook into the microphone system in the courtroom, and a person can either have it work directly with their hearing aids if they have a certain switch, or they can wear a headset, and that significantly helps them with their hearing because it reduces the distance they are from the person talking, and it allows them to adjust the volume. And so assistive listening devices are one of the other for the people who are hard of hearing that helps a lot. The next is mobility issues, and that's a variety of things from where can I park near the courthouse with accessible parking, how can I get in, I might need help with the doors. As you know, a lot of our courthouses, we have over 170 locations. A lot of them are older, and while we're improving accessibility and building great accessibility into our new buildings, it's going to take quite a bit of time. So in older courthouses, it may be we need to move the courtroom so that it's down to a first floor accessible courtroom, or it may be in some cases even having to move a case to another courthouse. But that can all be arranged working through the accessibility coordinator who will work with judicial officials where that's required. Some of the other types of requests are, I think we've heard a little bit today, was remote attendance, so telephone or video conferencing, assistance with forms at the counters. So there's quite a few of those requests actually as well, and that's somebody may need to read the form to the person, or they may need to actually scribe what the person wants said. Alternate formats of documents, and we even have a range of very complex cases, such as the hospital beds that were mentioned. So it's really quite a range, and as I think we've been telling you, is the sooner you can tell us, the faster, the more likely we can get the accommodation in place. Our accessibility coordinators are really great problem solvers, so if you can give them the time, they'll be able to help you.
Okay, thank you very much. Justice Bornstein, you've gotten a certain amount of feedback both leading up to today and perhaps today about physical barriers people encounter. Can you let us know what we're hearing?
Yeah, first of all, I can tell you we have over 60 questions here, but people are asking questions with respect to sorry, can we get this back on the iPad? For some reason it's just went blank. But people are asking questions with respect to issues of the aisles, wheelchair access, that sort of thing. What are the obligations of the government in order to ensure access at the front counter in the courtroom? Are they required to modify their existing structures, et cetera, to enhance services?
So this is a huge topic. Lori touched on it. I'm going to speak to it a little bit, and I'm going to ask Lori to speak just a little more. Most of our courthouses are old, and a bunch of them are rented. The Courts Accessibility Committee, the Ontario Courts Accessibility, that Justices Bornstein and Malloy and Ted Kelly, Joy and Cohen, a number of us are on, have been asking the government a lot of pointed questions about what are the plans to retrofit existing courts. And so far, we are still pressing on that topic. But I think it's fair to say this. The more you folks contact the government and alert the government to a particular building with a particular problem, the more you bring it up with your local law association or bring others to raise it, the more likely there is to be focused attention on that. And if you want to bring it to the attention of the Courts Accessibility Committee, you can certainly email me at david.lepofsky@gmail.com. You can click on the feedback link on the Ministry of the Attorney General accessibility page and send it in. And between all of these different avenues, and even just writing a letter to the ministry is a way of bringing to their attention. But for a particular proceeding, if there is a problem, or you anticipate a problem, you should notify the court access coordinator and either make suggestions or simply ask if you've got some practical suggestions. But if people don't ask, they aren't going to get fixed as quickly as if people do ask. Lori, is there?
Yeah, sure. No, just a lot, same thing. I think that the court accessibility coordinator is the best person to talk to, because if they do have to move it to another courtroom or to another courthouse, that can be done. In addition, we do have quite a lot of buildings and quite a lot of older buildings, and as David mentioned, leases. We are renovating. Anytime we renovate, we do increase accessibility, we do address accessibility issues, but it will take time. So it's really important to let us know what your problems are and work with the local staff to address it. They will address that problem. If you would like to let the ministry know in a broader way, you can certainly go to the ministry website, and I believe it's in your resources package. Our Commitment to Accessibility webpage has a section on how to provide feedback on accessibility. We want the feedback. We want to hear from you. We can't do everything at once, but we are planning on how to address everything across the ministry. So do let us know. We'd appreciate that.
And they're more likely to act. The ministry facilities people are more likely to act when a specific issue is pointed out by the judiciary, by the bar, by the public. What else have we got?
All right. Well, we're running short of time. How about this one? I am new to the court system, but as a visually impaired paralegal, I have found court dockets impossible to access without assistance. So what should somebody like that do?
Well, on this one, I'm pleased to tell you that a regulation passed in 2011 under the Accessibility for Ontarians with Disabilities Act that some of us fought very long and very hard for, includes requirements for the government to provide information in an accessible format to people with vision loss and other disabilities. And if it's in electronic format, the government should be able to either print it in Braille if you need it, or in large type, or provide it electronically so that a screen reading program on a computer can read it to you. The topic of meeting the needs of people with vision loss is a big one, and I'd like to see that addressed in another program. But there are specific regulations in place that set requirements about information access. The other good news is that if you're involved in a private legal proceeding, the technology exists in pretty much any law office right now to scan a document, convert it to a Word document, and thereby it or a TXT document, making it readable by any computer equipped with software that you can get for free now or at low cost, or even read on some handheld devices like an iPhone.
All right. Is there an obligation to accommodate observers, for example, people who are blind or need technology to hear? So they're not participants, they're not witnesses, but they're observers. And what do you do for parties who have cognitive impairments and want the support of someone who basically explains the case to them during the course of the proceedings?
Well, Justice Boyle, can I throw that one to you just as a start?
The observers.
Observers in the courtroom. It's a public courthouse. It's a public courtroom. People are entitled to be present, and they're entitled to know what's going on. But as a practical matter, we cannot have a sign interpreter present in every courtroom on the off chance that a person who needs that particular form of interpretation is going to be present. So bottom line is we need some notice.
Okay, no, that's fair. And in fact, there's case law out there that says that people have a constitutional right to become and observe a court proceeding. So if you combine that with the right to accessibility, there's an argument to be made. Let's try to fit in.
There's also case law that a person who has a disability and is seeking an accommodation has some responsibility for putting forward what their needs are before the duty to accommodate arises. So simply arriving at the courthouse and saying, I require this accommodation so I can watch this trial that's going to start in 5 minutes from now is probably not going to get you there.
Okay.
All right,
let's take one more question.
I'll try to combine a few. Essentially, the questions are as follows. What current strategies are in place to enhance access to the courts for people with disabilities?
I'm going to throw that to Lori just briefly.
Can you repeat it for me?
Yeah, sorry, yes. What current strategies are in place to enhance access to the courts for people with disabilities? Current strategies.
Right, are in place to enhance access to the courts. Well, we have quite a few things. One of the things I mentioned before is assistive listening devices. We are just rolling them out to every courthouse, as we had found that was the largest request. So we have been able to purchase for all our courthouses, and they will be all in place and up and running by the fall. A number of courthouses have things like wheelchairs, or again, not for a wheelchair user, but for somebody who may have stamina problems or fatigue issues, other needs in a long day in the courthouse. So not every court would have that, but some would. Different courts have different things because both the business lines may be different, but also the features of the court may be different. Some of the things you'll find in our new courts, the new builds, such as Waterloo, are very exciting, where we have a jury box that can move away and so that someone in a wheelchair can be included in the jury box. We have also the witness box can be adjustable and height adjustable. And even the counsel tables are height adjustable. So again, anything that's being made is we're trying to make it flexible so that it will meet the range of needs of people with a variety of disabilities. So there's a number of things that are available. But we also do go out and search out things sometimes. We have had to rent equipment or use services. And sometimes it's a matter of combining a service with extra breaks in a case. We had a case recently of someone who was both blind and very hard of hearing, and we used assistive listening device with personal interpretation with breaks so that they could catch up in the proceedings. So complex case, but you put the three together and it worked.
Okay, let me just turn it back to Justice Bornstein for one last comment.
I just want to add, you heard about the Ontario Courts Accessibility Committee, and David spoke a little bit about that and what we do as a committee with respect to dealing with, I guess the government comes to us with where they are at in terms of ensuring access to the courts. It's a very committed committee, but really there's very few people as committed as David is. David is a real tour de force on these issues. You know that from the TTC. If you live in Toronto, every time you hear a streetcar announce the name of the stop, you really have David to thank for it. And I think he is somebody you might, he brings so much to the committee, and he might be a good person to speak to, or email rather, to bring forward any issues of concern, and those could be brought to the committee, I would think.
Absolutely. Thank you very much. Let me thank all our speakers. I'm going to do about a 3-minute wrap-up, and then we'll end our program for today. First, I want to thank our speakers and the Law Society and for pulling this together. I want to thank all of you, all 1,100 plus of you who've taken the time to watch. We encourage you to encourage your colleagues to watch this on instant replay. We welcome your feedback. Please let us know what we got right, what we got wrong, and what you'd like to hear more of, and anything that we should be correcting. Please also, whether you email me or you use the ministry feedback page, or you want to email in to the through the communication for this program, it'll all get to us. If you have accessibility issues you think that the Courts Accessibility Committee should be focusing on, let us know. If you've got ideas, if you've got success stories, let us know, or areas that need improvement. I want to remind you for your own law firms that all organizations that provide customer service in Ontario were required by the public and private sector, were required by the end of last year to comply with the Customer Service Accessibility Standard under the Accessibility for Ontarians with Disabilities Act. You can learn more about that by going to the government website or to the my coalition, aodaalliance.org, and learn more about what's involved, what's required. The good news is complying with it is both the law and is good for business. There are also requirements under the regulations passed under the Disabilities Act, as I mentioned earlier, relating to information communication. You want to make sure your websites are accessible to people using adaptive technology. Don't spend money creating new barriers to your own services. It's not good for your profit. It's also not good for your clients, and it's also not good for your colleagues who have disabilities within your firm or your office. Second last point I want to mention is that I just want to remind you that whatever accessibility steps are required under the regulations under the Disabilities Act, they don't trump the Human Rights Code or the Charter of Rights. The highest accessibility law always prevails. So even if the accessibility regulations say you've got till 2015 to do something, if you can do it sooner, it's good for business. It's also better for reaching compliance with the Human Rights Code. And finally, while the Law Society has built this into a number of educational programs, if you're involved in any CLE programming and you would like to come up with ways to incorporate disability accessibility into your programs, to include it as part of your curriculum, get in touch with us because we can point you to curriculum and help you make sure it's covered, because it shouldn't just be a standalone program like this. It's wonderful when it's mainstreamed into other community legal, continuing legal education programs. With that, thank you very much for taking part, and until the next time, signing off.